Cognizable and Non-Cognizable Offences. 2. Bailable and Non-Bailable Offences. 3. Summons cases and warrant cases. ANS. Cognizable and Non-Cognizable Offence Section 2. C. Of Code define cognizable offences and cognizable cases, as cognizable offence means offences for which and cognizable case means cases in which police officer may, in accordance with First Schedule of Criminal Procedure Code or under any other law for the time being, enforce arrest without warrant. Then Section 2, L, of Code defines non-cognizable offences and non-cognizable cases as non-cognizable offence means offences for which and non-cognizable case means cases in which police officer has no authority to arrest without warrant. So difference between cognizable and non-cognizable offences lies in the fact that in case of cognizable offence, a police officer can arrest without warrant, whereas in non-cognizable offences police officer cannot arrest anyone without warrant. Column 4 of First Schedule attached to the Code of Criminal Procedure mentions which are cognizable offences and which are non-cognizable offences. In case of commission of cognizable offence, if matter is reported to police, then police will record the first information report under Section 154 of Code and shall proceed to investigate the matter and arrest the accused without any warrant or order of magistrate. But in case of non-cognizable offense, police cannot investigate without order of magistrate. Section 155 of Code provides procedure to be adopted by police in case of non-cognizable offences. Bailable and Non-Bailable Offences Section 2. A. of Code of Criminal Procedure defines bailable and non-bailable offences. Section 2. A. says bailable offense means an offense which is shown as bailable in the first schedule or which is made bailable by any other law for the time being in force, and non-bailable offense means any other offense. Column 5 of First Schedule in its first part mention which offense of Indian Penal Code is bailable and which is non-bailable. Second part of the First Schedule of Code deals with offenses other than that of Indian Penal Code and provides that all those offences which are punishable with imprisonment for term of 7 years or more are non-bailable, and all offences punishable with imprisonment for term of 3 years or more are also non-bailable, but offence punishment of which is imprisonment for term less than 3 years are bailable. Chapter XXXIII of Code contains provisions regarding bail. Section 436 of Code provides as to bail and bailable offences. Bail and bailable offences is a matter of right. Then Section 437 of Code provides as to granting of bail by magistrate in non-bailable offences. It also provides that magistrate shall not grant bail in offense punishable with death or imprisonment for life. However, in case of person less than 16 years of age or woman or sick or infirm person, magistrate may grant bail even in case of offences punishable with imprisonment for life or with death. Then Section 438 of Code provides for anticipatory bail, and Section 439 of Code then provides for bail by session court or high court in non-bailable offences. Summon and warrant cases. Section 2, W, of Code says summons case means a case relating to an offense and not being warrant case. According to Section 2, X, warrant case means a case relating to an offense punishable with death, imprisonment for life or imprisonment for term exceeding 2 years. So offences punishable with death or imprisonment for life or imprisonment for term exceeding 2 years are warrant cases, and any other cases are summons cases. Following are the points of difference between 2. A. For trial of warrant case by magistrate, 2 procedures are prescribed. 1 is adopted by magistrate in cases instituted on police report, sections 238 to 243 and 248 Cr.P.C, and other is for case instituted otherwise than on police report, sections 244 to 250 Cr.P.C. Whereas, there is only one procedure prescribed for trial of summons cases, sections 251 to 259. B. Trial of warrant cases as summons cases is an irregularity which vitiates the trial if prejudice is caused to accused. But trial of summons cases as warrant cases is only curable irregularity within the meaning of Section 465 of Code. C. Where a warrant case is tried as summons case and accused is acquitted, then order of acquittal will operate as discharge under Section 245, and where a summon case is tried as a warrant case and accused is discharged under Section 245, it will operate as order of acquittal. D. In a warrant case, framing of charge is necessary, whereas in summon cases framing of charge against accused is not necessary.